If you think failing to disclose property issues in a real estate deal is no big deal, think again. These sellers hit a critical encroachment problem until the buyer found out. They got sued. Hi, I'm Viviana with the Realty Group, and I'm a licensed real estate agent in this beautiful province of Alberta. This is our team's brand new channel, Live in Alberta, here to help you with everything real estate. If you've ever wondered what buyers and sellers get sued for in real estate transactions, I've got a video for you. I'll break down a court case and talk about what you can do to protect yourself as a consumer and what we as agents can help you with. And if you like this content, please like, share, and subscribe, help a new channel out. So today I bring you a case from 2010, Baker versus Warshawski. This case from Calgary is a real eye-opener for anyone involved in real estate. You can find all of the details on canley.org, but I've got the highlights. Baker agreed to purchase a home from the Warshawskis. This house had a unique, beautiful C-shaped courtyard, which sealed the deal for the buyer. However, unknown to the buyer, part of that courtyard wall was built on the neighbor's property, and the seller didn't disclose this to the buyer. Instead, they tried to problem solve the issue themselves with disastrous and expensive results. So a year before they put the house up for sale, the sellers and the neighbors spoke about replacing a section of the fence, and they had a conversation that probably went something like this. Hey, did you know your wall's built on my property? No, I didn't. I mean, it's no big deal, we're good neighbors, but I just wanted you to know. Fast forward a year and the sellers commissioned a real property report for the sale. And sure enough, it showed that they have a problem. Everything was entirely within the boundaries of the property except part of that courtyard wall encroaching 4 inches onto the neighbor's land. The real property report is a survey that shows where the house and improvements are located on the property. So house, detached garage, shed, deck, air conditioning unit, window wells. This report is very important when it comes to what the seller is warranting to the buyer about the land and the buildings and improvements that are on that property. The City of Calgary stamped the RPR with compliance and mentioned the encroachment. So the seller's lawyer says the easiest thing to do is get an encroachment agreement signed and registered on title. This means they're officially addressing the encroachment and saying that each of these parties is okay with it, and when they register it on title, this agreement runs with the land, so any future buyers have to be okay with it too. Well, the neighbor didn't want to sign the encroachment agreement. He changed his mind. The sellers even offered him money, but it wasn't about the money, it was about protecting his estate. And then, in a ballsy move, he told the sellers, I actually want the courtyard wall removed and replaced with a basic fence. And he had gripes about other stuff in their yard. Arr. The seller's lawyer went over the next day to talk to the neighbor, no agreement. The seller's agent brought him cookies, no agreement. And that same day, the sellers get an unconditional take it or leave it offer to purchase, where buyer's agent asks about the RPR, and the seller agent says, they have an RPR with compliance, it's at the lawyers. Tricky, tricky. When an agent says that, they're implying there's no issue with the RPR, but there clearly was here. The lawyer advised the seller that if you don't have an encroachment agreement signed, you need to move that wall. At this point, they're headed into fall, and it was near impossible to find a contractor to get the work done on short notice and completed before the closing date. And at no point in time did the seller agent communicate any of this to the buyer agent. The lawyer sent the RPR to the buyer lawyer and discussed the encroachment situation. This is where the buyer began to think she'd been tricked. So she set out a few options she thought was fair. Option 1, closing subject to the receipt of an encroachment agreement. So if you can't get an agreement signed, I'm not buying your house. Option 2, if you're going to alter the courtyard wall, I'm involved, non-negotiable. I have the right to approve contractors. I have to be satisfied with the alteration. It has to be identical in design and construction. We get construction approval from the neighbor, or you indemnify me with respect to any future legal disputes with him. I get $100,000 off the purchase price and a new RPR, and if all these conditions are met, we can close 5 business days after that. And I'm not paying interest or any other costs. Oh, and also if the construction can't be completed by November the 30th, I walk away with my deposit. Not messing around. Third option, we're done and we don't owe each other anything. Give me my deposit back. So the seller's lawyer responded that the sellers couldn't find a contractor to do the work. So options 2 and 3 were not actually options for them. He said that they could possibly get an encroachment agreement, but could they? As fate would have it, a contractor happened to now be available and started the work like a day later. And of course, the sellers didn't tell anyone they were doing this, and the buyer drove past the house seeing a demolished mess that was the courtyard. Hell no. This was 4 days before closing. Buyer's like, I'm pregnant, I'm not dealing with this, I'm out. So there are 3 contract terms that were significant to this case and dictated some of the actions that were taken. In Alberta, we have the Alberta Real Estate Association boilerplate contracts we use, where section 4.1 says that when the buyer takes possession of the house, the property will be in substantially the same condition as it was when the contract was accepted. So no holes in the wall, no missing appliances, no demolished courtyard. Then in section 6, we look at what the seller is warranting to the buyer. 6.1e says the building and its improvements are entirely on the land and don't encroach on neighboring lands, except where an encroachment agreement is in place. And 6.1f says the location of the buildings and the improvements comply with all relevant municipal bylaws, regulations, or relaxations granted by the appropriate municipality prior to the completion date. So you can see the bind the sellers were in, where the easiest way to deal with this encroachment was to get an encroachment agreement, but with an extraordinarily difficult neighbor, they couldn't. And the only other option was to move the wall. And then if you alter the wall, you're in breach of section 4.1. It's like this lose-lose situation, made worse by trying to problem solve and not communicate anything to the buyer. That buyer must have felt like she was deceived over and over again throughout this deal. So the judge found that the seller's failure to disclose the encroachment and the drastic alteration of the property were significant breaches of the contract. This justified the buyer's decision to walk away from the deal. The judge ruled in the buyer's favor, allowing her to rescind the contract and get her deposit back as if nothing ever happened. The sellers actually counterclaimed for damages in the hundreds of thousands because they remediated the wall and they ended up selling the house for less. But that counterclaim was dismissed because none of this was the buyer's fault. So what did we learn from this? Whether you're a buyer or seller, full disclosure and understanding the contract are crucial in real estate transactions. Any unexpected changes can lead to significant legal and financial consequences, like the sale of your house collapsing. And as your trusted agents, we're used to communicating with your lawyer and we deal with this stuff all the time. Full disclosure is always the way to go. It opens up conversation lines to problem solve with the other party, and it helps us help you determine the best way to go about tackling these issues. The Live Realty Group is here to help, ensuring a smooth and transparent process. And if you found this video helpful, please don't forget to like, share, and subscribe. Ring that notification bell so you never miss a video from us. See you next time.